One thing that I always encourage clients who are coming to me upon divorce is to consider whether they need to apply for a matrimonial homes right notice with the land registry. These are particularly useful to have on a land registry title when your divorcing spouse owns their property in their sole name and you don't have any interest in the property or any legal mention on the legal title to that property. So a matrimonial homes right notice would place a notice on the land registry title to your ex-spouse's property to say that you have a potential interest in that property, and if there was any change to the property title, for example your ex-spouse tried to sell it, or they tried to transfer the property title into somebody else's name, then you would be receiving a notification from the land registry to let you know that that would be happening, and it would also flag up to any potential buyer or transfer that potentially someone has an interest in that property and that property shouldn't be transferred or sold. So that's something that's really key to consider if you are looking to resolve finances and you are worried about potentially your spouse changing the land registry title before the finances are divided. You can only have one homes right notice per person, and you can only have it on one property per marriage. The homes right notice will automatically be removed upon decree absolute, so when you've reached your final stage of divorce. So it's really important that you do resolve finances before you reach the end of your divorce and receive your divorce certificate, because if you haven't resolved finances by that point and you do have a matrimonial homes right notice, that will no longer apply, and that could then present risks to you. So what I would do in those circumstances is ask the other party to provide an undertaking or an assurance that they won't apply for decree absolute or the final decree of divorce until the finances have been resolved, and then that gives the other party protection. What I would suggest is that any clients do receive legal advice, because every situation is different, and there is a potential risk that if you own a property in your sole name, that your ex-spouse could also register a homes right notice on your property. So be clear with your ex-spouse if you are going to potentially sell or transfer the property for legitimate reasons and the money is going to be held to order, for example. But get legal advice, because every situation is very different and there can be certain implications with one of those homes right notice that could potentially impact on your current circumstances, so do get some legal advice.